We have one administrative function, Appeal 2862. We have a letter from Bradley Palmer regarding the above referenced matter before the Zoning Hearing Board. Please continue this until the next meeting of the board in October. Any objections to that? The last one on our agenda.
2862.
2862.
The sign one?
The sign one, yes.
I have no objection.
Okay.
Mr. Chairman, I would note that the deed in that file was incomplete. They should bring a complete deed. Now, we just did this, we had this appeal on, I think, 2859 or something like that. We issued a decision in June, so maybe the township already has a complete deed, but the deed that I got didn't have a signature page, just had a front page.
2862?
Yes, the 2862. I did not.
Okay.
That's the 134 North Wayne Avenue. I
Okay,
did
Mr.
not
Palmer.
have a complete copy.
We need a complete deed. All right, we make sure that the file gets that. Okay, continued until next month. The next thing on the agenda is Appeal 2857, and it's continued from last month, or from the previous month's hearing, and I have recused myself from that. So Mr. Dolan will be the chairperson.
Again, this is appeal number 2857. The applicant, the Jewish Federation of Greater Philadelphia, property located at 270-276 South Bryn Mawr Avenue, Bryn Mawr, PA, and is zoned PI. Applicant requests a special exception pursuant to Section 28068 of the zoning ordinance to permit the construction of a, quote, home for the indigent or the handicapped, end quote. In addition, the proposed home will be an accessory use to the primary use on the property, Barak Hebrew Academy, insofar as a portion of the residential units proposed will be used for the housing of students, faculty, staff, and employees. Mr. Falcone?
Good evening. My name is David Falcone. I'm here on behalf of the Jewish Federation of Greater Philadelphia as well as J-High. At our last meeting before this board, we were asked to submit a memorandum of law for the board's consideration with respect to ambiguity in the zoning ordinance to permit our proposed use as well as the existing Barak Hebrew Academy use on the property. We believe that the record's been closed with respect to testimony, but we are awaiting a determination from the board with respect to that memorandum.
Did you want to give us a summary of the argument, or would you want to just let us live with the papers?
We believe the papers speak for themselves.
Okay, very good. Thanks.
I will say for the record, I do have with me this evening representatives from both J-High and the Federation, should any questions arise with respect to the material contained within the memorandum.
Okay. Do any members of the board have any questions?
Mr. Chairman?
Yes.
Is it worthwhile that he explains what is contained in the memorandum?
Well, the council's indicated he'd like to let it rest on the papers.
Mr. Chairman, I'm happy to explain the memorandum.
Okay.
If the board would appreciate that.
The idea is that it's a public meeting, that everybody know what decision we are taking is based on what they heard too.
It's no problem. We submitted on August 31st a memorandum of law outlining our position with respect to the language contained in the ordinance. The primary argument that we submitted in our memorandum was that the language of the zoning ordinance is ambiguous with respect to use within the PI district. The language contained in the ordinance, we believe, permits multiple uses, which you designated as A and B uses within the PI district. The use which we propose is a use which is specified in the B category. C category is an accessory use provision, and that gets to the housing of faculty and students and so forth. We believe when the ordinance in that section in particular is read in total, the language clearly allows for and contemplates multiple uses. Most specifically, by continuing through the ordinance and looking to sections with respect to setbacks and general area and bulk within the district, the language of the ordinance contemplates multiple tables, that describe different uses and their required setbacks and so forth within the district. The specific language states, in part, if a building contains a mix of uses or includes features which are covered by more than one classification, the entire building shall meet the requirements of the highest classification, which applies to any of the uses and structures. If you look at the Category 1 uses and the Category 2 uses specified in that section, it is a blend of your A and B uses. So to contemplate a building having a mix of uses clearly contemplates that the building could have A and B on the same property, which is a PI district. There are other arguments contained in the memorandum. We don't believe those are necessary. They're in the alternative arguments, but certainly we believe that if the use is deemed not to be appropriate, that there is a Fair Housing Act argument that could be made that would allow us to place this use on the property. But we believe firmly that the language of the ordinance is at the very least ambiguous, and pursuant to Pennsylvania law and the MPC, where there is ambiguity, it is without question to be ruled in favor of the applicant. And the definition of that ambiguity is where two reasonable minds could differ. In this case, we had several folks at that hearing that interpreted the ordinance differently. The applicant, some members of the board, as well as the board's solicitor. It should be noted that John Rice was asked at the hearing if the township had a position, and he specifically stated, and I will quote it, it's quoted in the memorandum, I think it's relevant. So, excuse me for 1 second while I find that language. He states that the township supports the application, that's a quote, and that, quote, there is no issue from the township's perspective with this application. We found that to be relevant from a township perspective. That is a brief synopsis of the memorandum and the testimony that was presented at the hearing.
Okay.
Thank you.
Now, let me take up where we left off last time.
Yes, sir.
I'm going to tell you my analysis of this as a discussion with the members of the board, and then we'll see if we can all come to some kind of an agreement, one way or the other, with a vote. No one argues that multiple uses are permitted here. For instance, the university might have a building that has a dormitory, a dining hall, a meeting room. What this ordinance deals with is principal uses. In the case of a university that has all these things in one building or multiple buildings, they're all related to the principal use. But we're talking here, I think the facts were pretty clear. We're talking about a principal use that's really unrelated to the principal use of the school. It really doesn't have much of a nexus to it. I mean, there may be a casual connection if someone gets a job there part-time, but these are not students at the school. I think that was established on the record. And these are not faculty members of the school, and they're not staff people at the school. So the real issue is whether we should read in or read out the word one in Section 28068. There are many sections in this zoning code that deal with different uses, and what they generally say is you may use property in this district for any of the following uses, and then it enumerates them. In this case, it's either unique or pretty unusual for this code. It says for principally used or occupied for any one of the following purposes. It's not that I don't have a feeling of support for your use. It's not that I feel it's inappropriate for this property. It really comes down to whether we have the authority to act, and the only way we could do that, keeping in mind we're not the legislative body, we have to live with the code as it is if there were no reasonable interpretation for the words as they are here on the page. And there is a reasonable interpretation. I think we've all gone into restaurants where we are buying something, buying a dinner on a menu, and it says you may have any one of the following entrees. And we expect to order one entree. We don't expect to be able to order two. Now, I think the thing for you to do, and I don't see anything on the record, by the way, today that would keep me from granting a special exception if I felt I had the authority to do it. I've heard no evidence that this is going to be detrimental to the community or otherwise wouldn't qualify for a special exception. I think what you need to do is go to the Board of Commissioners and ask them to amend this section of the ordinance. It's possible they would take out the word one and leave it at that. It's possible that they would not take it out but make an exception for properties of a certain size. There are all kinds of ways they may elect to do this, but they must do it. They're the governing body. They're the legislative body. And as long as it says any one of the following purposes, and you have one of these purposes going on now in the form of a school, I don't think we have the authority to grant you the special exception for this particular use. So that's how I have analyzed it, and I think it's a matter of fact for us to determine whether we think there's an ambiguity in this language.
And I think, I respectfully disagree with you, Mr. Cutler. I certainly understand your analysis. I think it's a detailed analysis, but I just don't think it arrives at the correct conclusion. I think if you're going to flip to other sections of the code and look at the code as one body, which it should be interpreted, I just don't see how you or this board can ignore the very next provision in the pertinent section, being 280, that deals with, it doesn't talk about if a building contains any mixes of principal uses. It simply says if a building contains a mix of uses or includes features which are covered by more than one classification. That it contemplates, this ordinance contemplates a PI property housing potentially one or more A and B uses. That's how we interpret this ordinance. We think it's ambiguous because the language that you cite, which absolutely is the language of the ordinance, does say any one principally used or occupied for any one of the following purposes.
Is there a language that talks about multiple principal uses on a property? Could you cite me to that? I didn't see that.
No, nor did I.
No, there isn't, I don't think. I don't think there's anything in here that later on contradicts this by contemplating the situation that'd be multiple principal uses on a PI zone
contemplates
property.
multiple uses.
But not multiple principal uses.
But it doesn't
like I said,
contemplate
let's say my
multiple-
principal use were a university.
Yes.
And I might have, as part of that use, I might have a stadium. I may have athletic fields. I may have a dormitory. I may have dining halls. I may have faculty housing, all kinds of things. They are multiple uses, but they're all related to, have a close nexus to the principal use, the one principal use of a university.
But the flaw in that argument is that C contemplates the only accessory uses in the provision. A and B contemplate primary uses. C contemplates accessory uses. This is not an accessory use by itself. It is a separate use. So it's a B use, is what we're discussing.
I agree. What you want to do is a B use.
That's correct.
I'm telling you that in my interpretation, it's actually pretty clear here, I think, is that we can only grant a special exception B use if it's the principal use of the property.
And
If there's another principal use going on at the property, we can't have two principal uses.
And what I'm saying is the B uses that are specified along with the A uses are uses that are often combined in districts. And that is, again, the information that Mr. Ryan so clearly pointed out at the last hearing.
I have a great deal of respect for Mr. Ryan, but this is a decision for the board to make, you must understand.
I understand.
Factual matter as to whether we find an ambiguity. And as a member of the board, I'm saying I don't. I kind of wish I did.
Right. So do
but
I.
I don't. And I think there's an easy way around the problem, which I am telling you just as a suggestion.
And
it's certainly not my role to do that.
I do appreciate that, but amending the ordinance, I wouldn't.
Principal use is not barrack, it's Federation mission.
I certainly appreciate your suggestion, but I would not suggest that amending the ordinance is in any way an easy task. And I don't think it's a task that should be undertaken when there is, as we believe, very clear ambiguity in the ordinance. And when there is ambiguity, it should be ruled in our favor in the least restrictive means. That's uncontradicted law. And I just don't see that when you read the ordinance as a whole and the language that are here, and when you look at the Category 1 uses, the Category 2 uses, the A uses, and the B uses, and an overall ordinance that contemplates a blend of all of that, you can say that the ordinance contemplates that you can only have one A use or one B use. That's just not what the next provision says. The next provision says, and I hate to keep going back to it, but it's the clearest evidence of ambiguity. The following table includes many of the projected many of the projected uses in the planned institutional district. If a building contains a mix of uses, so we're not even talking about on the property, we're talking about in one building even, contains a mix of uses or includes features which are covered by more than one classification, the entire building shall meet the requirements of the highest classification. And then the classifications blend the A and B uses.
I'm sorry, Mr. Falcone, if I'm not making myself clear.
Oh, you're making yourself clear.
I don't disagree that there may be multiple uses on a property in this district. That's not my argument. I'm not saying that I disagree with you there. There are often multiple uses on a property in this district, and it's provided for. But there may not be more than one principal use. And in this case, there's no nexus of any substance between the use you're proposing to put in this new building and what I understand to be the principal use of the property.
So perhaps I'm not making myself clear, because A and B provide the only possible uses outside of an accessory use in the district. So when you say there can be more than one use, you're saying there can be one use from A and B and an accessory use.
No, we're talking principal uses of the district.
There can be one use from A and B, which you've just said are the principal uses listed for the PI district, and the other uses, which are C, are the accessory uses.
No. That's not what I'm saying. I mean, that is true, but there's more to it than that. In having a principal use, like a university, like a prep school, like all kinds of things, like a hospital, in having a principal use, there are many uses that are related to that use or consistent with it and connected with it, like a dormitory with the university. Housing is not necessarily teaching, but it is certainly related to have dormitory housing on a university campus. So we're talking about, I'm not saying that it's not permitted to have multiple uses on the property in this district. I'm saying it's not permitted to have multiple principal uses. And unless these two are interrelated uses, whereas one is subordinate to the other as the principal use, this ordinance as currently worded doesn't give us the authority to grant you the special exception.
So,
that's all I'm saying.
And I appreciate that. So going from your example, where you believe that this allows multiple uses, so the example then, and a good one I think, which you find often, is a hospital or a school with an attached hospital or medical facility, a medical school. The school is an A use. The medical facility is a B use. By your definition...
Only if they're principal uses.
They can't be anything else.
Yeah, they can be.
How?
In other words, let's say I have a university, and as part of the university, I have a student infirmary.
Mm-hmm.
It's
That's
okay
a
to
B
have that
use.
infirmary, no, because B is a principal use. It's okay to have the student infirmary if it's not a principal
the ordinance
use.
permits that? Can you point to that provision?
Yeah, at
Because-
the very beginning of 28068 says a building or combination of buildings may be erected or used, and a lot may be principally used or occupied for any one of the following purposes.
Where does it permit one of these uses?
This is all definitions of principal uses that are permitted. You are permitted to use it principally for anything listed in A without having to get any special zoning relief, or you're permitted to use it principally for anything listed in B.
Then we're not a principal use.
By getting special
Then we're not
relief.
a principal use.
You're not? What isn't?
Then J. High's facility is not a principal use.
It is because it's not related to the school.
This ordinance does not account for that relation, sir. A and B are not...
But it's related to the Federation mission.
Okay, thank you. There is no distinction.
Well, let me
You
back
are
up and ask you a
trying to-
question. Maybe we're disagreeing on something else.
Okay.
What is the principal use of the property?
The principal use of the property is the Federation's mission.
So it's not the school.
It's the Federation who runs the school, and it's their
But
mission.
what is that? I mean, is it a college? Is it a private or parochial elementary or secondary school? Which of these things is it? If it's not the school, I mean, we understood that the principal use of this property was for the Barrack Academy.
And that is the use. That is in furtherance of the Federation's mission.
So is
That's
that the
school.
principal use, a school? That's permitted. Is it something else?
Are there Federation offices unrelated to the school on the property?
Yes.
Okay. What are the other operations that the Federation has on the property? And perhaps a witness ought to testify to this.
Dominic Vallone is here.
So
I do. My name is Dominic Vallone. I'm the Director of Operations for the Jewish Federation.
okay, Mr. Vallone, would you describe for us, frankly, all of the operations in addition to what the Barak Hebrew School?
My operations go to a number of campuses. Most of our campuses are dedicated to the Federation mission, which includes educational training facilities, child care, a number of social service provisions. We purchased this property in 2000, I think it was 7 or 8, with the intention of developing the campus to further our mission. Our first tenant was the Barak Hebrew Academy, which had moved from Lower Merion and formerly known as Akiba Hebrew Academy, longstanding, very well-respected school. We renovated 2 of the 6 buildings, I believe, for their use. At the time that we purchased the property, Villanova University had office use in one of the buildings. They have since terminated their lease. We also have American College, which is an unaffiliated agency that runs insurance kind of educational programs. They originally owned the entire campus. We bought the campus from them and then leased them back one of the buildings. But we have a number of facilities that we intend to use for Federation mission. This Barak is simply a tenant of the Jewish Federation. They are an agency that receives funds from the Federation, and we support them. And we're very happy for them to be here. But this is not the Barak campus. This is the Schwartz campus, which is dedicated to the Federation mission.
But you have to understand, our concern is with use. So I understand the Federation owns the property, but the zoning code deals with uses and structures and dimensions. So we need to know what the principal use of this property is so we can figure out how to deal with this case under this zoning code.
I understand that, Mr. Colorado.
So what is the principal use of the property? As the owner, I'm asking you, pick one. What's the principal use of the property?
Well, actually, I do not know the law, but I could use some coaching here. I'm not quite sure what principal use
Get all the help you need.
would follow under the mission of the Jewish Federation of Greater
You see, it's not ownership that's the issue, because you could decide to run a hamburger stand to raise money for the mission, but that would not be permitted, you see. So it's ownership that's not the issue. It's use that's the issue, principal use, not ownership.
So I guess we get back to then the question, if the principal use is the academy,
Well, is it? I'm asking. I'd like you to confer with your client and tell us if I'm wrong, it's not the academy, then I need to know what it is so we can figure out how we apply this section. We've assumed it was because this is our second application for this academy on this property.
if we could take a minute.
Sure.
Thanks.
We're going to take a 5-minute recess.
A 5-minute recess would be great.
Thank you.
I don't think he got into that deal. We haven't got, the township doesn't have a problem with us.
Waiting for our solicitor to return to the room. Are you ready when we are? Great, thanks.
Mr. Falcone?
Mr. Dolan. So I've conferred with my client, and we believe that the principal use on the property, if forced into one of these categories, would be an educational institution, which is referenced in A. But we also believe that, using Mr. Cutler's example of a campus environment, that all of the uses listed by Mr. Vallone, as well as the J High use, if you reference back to the testimony that was presented before the board at the last hearing, fits into that one congruent mission which we spoke of, which Ira Schwartz, who was president of the Federation, was here, and Ms. Creed, when she spoke about it. And the educational component of the facility we're proposing is very real due to the nature of the residents that are there. The main component of that is teaching of life skills and blending of skills as well into the academic component with the Federation. That was discussed by both Mr. Schwartz and Ms. Creed. So looking at the entire campus, which is no different than looking at a medical school campus with different buildings that perform different functions, this is another function within the Federation mission. The Hebrew Academy is one.
Well, can I interrupt you on one thing? You keep using this phrase, Federation mission.
Yes.
And I think I know what you mean. I think you're saying these are the things, these are the good works which the Federation is formed and maintained to advance in the world. Right.
Yes.
But that's like saying General Motors makes cars. And because General Motors makes cars and they have offices, they have warehouses for parts, they have factories, they have raw materials, they have everything. Doesn't mean that all that can be done on one property because General Motors owns it and it's consistent with their mission.
Sure it does.
The property may allow them to have office use there or an auto plant, but you can't bring all uses under the umbrella because of the ownership. But use is what's being regulated.
Using your example is a good one. If we're going to talk about building cars, maybe you would say the primary use of that facility is the construction of automobiles. But there may be other uses on the property that are used in furtherance of that goal. One being office, perhaps a marketing department, perhaps a marketing building, a sales department. Any of those things have really
well, that's where my analogy breaks down because that's a for-profit group, obviously.
But you can't.
But I mean, you could do all kinds of activities that are charitable. I mean, there are charitable organizations that do all kinds of things.
These are educational.
But you couldn't do them all on this property.
But these are educational.
Are these people going to be students? All students at the
They are
school,
not, and but that has nothing to do with the purpose. You're drawing a line that's not there. Just because the residents of the J High facility are not students of the one school building there does not mean they are not a part of the purpose of the facility, of the campus.
Of the school facility?
Of the campus. You're focusing on a school facility being the only possible use.
No, because that's an allowed principal use. And if that's not the principal use, tell me what is. That's what I want. Tell me if I'm wrong. We perceive it that way.
It's an educational institution. The whole facility is used for educational purposes. There's not one building there that is not used in furtherance, even including the J High, of furtherance of education. The education within the J High building is for life skills as well as blending into, again, you can go back to the testimony, will be used in conjunction with the Hebrew Academy to incorporate those individuals into that environment, to educate them in that environment, and to use the students to allow them to have the educational experience of having these folks on the campus. There are offices on that building. There are offices.
What's it we're talking about?
Just talking about when I leave the home, go to J High, it's like going to college, separate from my parents, about teaching them new skills, blah, 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 blah. So it's important, right?
But it has nothing to do with this. Well, I don't know.
Just like all the American companies. Can you turn your radio?
Excuse me a second. Okay. Well, I'm ready to move this for a vote unless there's other discussion from the board or you have other facts you want to put in the record. I mean, at this point, we're just repeating ourselves. Are there any other facts you want to put in the record? Or is the record closed on factual matters from last time? Did we close the factual record? Yeah.
So I think it is important to summarize then where we've gotten tonight, because I think we've ultimately gotten right back to the same place. We have an educational institution as a primary purpose on this campus. That educational institution is the Federation, and the buildings on the campus are in furtherance of that purpose, your one principal purpose. And there is no distinction drawn in your ordinance with respect to that. And even the examples that have been discussed tonight, I think, fit perfectly within that. If you need your one principal use, your one principal purpose, it is the educational institution. Life skills are taught both at the academy, at the J High facility, and across the campus. The residents and the students and the officers and the workers on the campus, both in the administrative role for the Federation, the administrative role for J High, as well as the administrative role for the school, blend in furtherance of one goal. And I think that's consistent with your ordinance, and I think we are entitled to a special exception.
Mr. Chairman, Mr. Chairman, it just occurred to me, we effectively reopened the record when we took testimonies. You will have to close it again, I think.
Okay. Okay. Do you have anything else?
No.
Any other questions from the board? Yeah.
You have to address the chair.
Mr. Chairman, Ms. Creed would like to offer some testimony if that's possible.
I'd be happy to. Has she been sworn previously? She was.
Yes.
So,
Judith Creed. I think the point in my ears that hasn't been made clearly, because Mr. Falcone isn't intimate with J High, is that J High is all about education. This isn't a facility for housing the disabled. The building is there, but the purpose of J High is to educate the disabled to live independently. Everything we do is about training and education. Anybody can throw disabled people into a building and say they're living there. J High is unique. It is very well thought of, and anybody who has a handicapped person that's of age would want them to go into the hands of J High, because there they know the disabled person will grow. They won't languish. They won't be sitting in front of TVs. They're going to be trained how to work. They're going to be job coached. They're going to be counseled on how to deal with their issues. The idea is growth and education. This is not about housing disabled. And if you read the brochures that we gave to you, you'll see the list of things that we educate in. We've listed them. I think either I didn't do a good job last time in testifying, or you just have to know us more to understand the words that we're saying, that this is a much bigger thing than housing the disabled. This does fit completely with education. We'd have a much easier job if we didn't.
Ms. Creed, let me ask you a question. When the residents are educated, when they've been taught how to work and how to live, do they then go off into the community to do that, or do they stay in this facility?
Oh, they go into the community to do it.
So they don't stay living here. They're taught and then
they stay living because they have certain limits that they can't get beyond. But there are other kinds of limits that absolutely can be taught. As a matter of fact, we have, at the beginning of every year, we have goals written for every one of them. Now, it's not learning to be a PhD in science. Maybe the goal is that I'm going to cook dinner by myself. Or maybe the goal is I'm going to be able to balance my checkbook. Or maybe the goal is I'm going to do my laundry on my own. But it's educational. It's just at a different level of education. You don't get a degree from it, but if you pass your goals, then you have new goals to grow from. And that is educational by anybody's definition.
Well, I'm sure there's a definition of education that'll encompass almost any activity. I
Well,
appreciate.
I would
I
argue
appreciate
with
what you're
that.
saying. I mean, I don't want to get into an argument with you. I'm just saying that I get the impression that if someone were 50 years old and were functioning, he'd still be in this place even though he's held the same job for 20 years. And cooks his dinner every night. I mean, he'd still be there. This is basically a residential facility with additional amenities, with additional benefits. Same as a rehab hospital might be. If I were learning to reuse my arm, for instance, like I had to do. You know, I was in a place where they taught me to reuse my arm, but it was a medical facility. It wasn't it wasn't the school because they were teaching me something. I don't really want to split hairs, but I understand what you're saying. But everything is educational. I'm learning things tonight. Is this a school? I mean, let's be realistic about what the principal use is.
In fairness, though, I would ask the question, where would these residents be if they were simply put into a residential facility and didn't have the training? Just because they don't graduate and leave doesn't mean that the instruction and assistance they're getting at the facility doesn't bring them a lot further along.
But I understood, John, this started in homes, in private homes that were rented as group facilities, as homes, not offices, not schools, not campuses, but a house that might have housed, what, six or eight?
No, the
six or
group
eight
homes
residents?
were always educational in the sense that we differentiated ourselves from the kinds of group homes that the city has
Right.
and puts people in.
But they weren't schools. They weren't called schools. They weren't in a place zoned for schools. They were
It's
a
not
residence.
called a school.
Right.
That's right.
It was in a residence.
But they are coached and they are job coached. They may not change jobs, but for instance, my son got promoted in his job. How did he get promoted? It wasn't an accident. It was because we taught him skills for his job. We job coached him, and he got promoted, and he got a raise. That wasn't an accident. That was because we taught him skills that he could apply to his job.
I understand your point. That
Okay, as long as you understand
some
that
learning goes on at these facilities.
A lot
Yeah,
of learning
okay.
goes on.
But would you call it a school?
I don't want to belabor this, but the ordinance doesn't reference schools. It says an educational institution. That's what the ordinance says. So let's...
Actually, what it says is college, private, or parochial elementary or secondary school or other educational institution for academic instruction is what it says.
So how is what they're teaching them not academic?
Is this academic instruction?
Yes.
It's absolutely academic.
I understand that's how you want to characterize it.
It's how we.
It's a
how
question
it
of
is
fact for us to
characterized.
determine.
But you
Please, let's
can't
not get
make this
argumentative with each
determination.
other.
What you're doing now, Mr. Cutler, is you're splitting hairs in this ordinance for no relevant purpose. It's an educational institution. You have testimony from the highest possible individual in this organization and a brochure that's handed out. It
But
is
of
what
course,
it
we
is.
can weigh the testimony as we deem appropriate.
It is what it is, Mr. Cutler, and you can't determine it otherwise because you feel like you want to, or whether you don't want to or you do want to. It is what it is, and it's an educational institution. And if we read your ordinance as clearly as you want to read it, it deserves a special exception. And you cannot graduate from every educational institution, and it is not similar to your rehab. These individuals will not get full use of their arm back, as you did, and walk away. They won't get a
Taking
diploma.
that comment out of context. I just said not every
It's
place
your
where learning
example,
goes on is
but
a
it's
school.
your example.
That's all I'm saying. Learning goes on in your house.
Use a relevant example.
Okay. Enough.
Well, I move that the special exception be denied on the grounds that we don't have the authority under the ordinance because an existing principal use takes place, and this would allow a second principal use to take place on the property.
Okay. Brad, what do you think?
I think I'm of the opinion that there's enough testimony in the record to justify that the structure is going to be part of the educational institution for academic instruction.
And so you'd be in favor of granting a special exception?
That is correct.
Okay. Cora?
I do agree with that, right? In the sense, I was listening to I wanted Mr. Falcone explain again the memorandum of law, and I understood there is ambiguity. Being a non-lawyer, it was much more clearer from the discussions we had last time that it is a social need to take care of this kind of youngsters or adults, we call it. And it is an institution in the sense they are training the people, the youngsters who are handicapped or disabled, and they have a routine training given. And I agree, that it is a training, laboratory for them to make them live a healthy life in the future. So I do agree with the analysis given by the applicant, and I support for granting the special exception.
Okay. I believe that there was probably enough evidence in the record to support a contention that this is an educational institution as well. So I would vote to grant the special exception as well. So it's granted.
Thank you.
Thank you.
We're going to skip over the next one and proceed directly to appeal number 2861. Mr. Falcone, did you want to just come on up and tell them why we're doing that? Is Mr. Falcone the younger counsel for this one as well?
Yes. Put my glasses on. An appeal
2861.
2861. I'm also recusing myself again because my son is the opposing counsel.
Okay, thank you. The next matter we're going to cover, and Mr. Falcone has left the room. Notwithstanding the fact that he's not in the room, we're going to do 2861 appeal C.F. Holloway III and Company, property located at 40 Luella Court, Wayne, PA, and is zoned R4. Appellant appeals the Township Zoning Officer's determination dated June 10, 2000. Pursuant to Section 28139, the determination misapplies the zoning code and is inconsistent with Pennsylvania law. The determination also misapplied the facts related to the property. If the board should deem the appeal unsuccessful, appellant seeks, in the alternative, a special exception pursuant to Section 28101 of the zoning ordinance to permit the expansion of a nonconforming use or building to allow for the construction of an underground garage beneath property which is presently used for parking as part of a nonconforming multifamily residential use. In addition, to the extent deemed necessary by the board, a variance from the requirement of Section 28101 to permit an area devoted to a nonconforming use to be increased by more than 50%.
Good evening, Mr. Chairman. My name is John Snyder. I'm with Saul Ewing. I'm a partner of Mr. Falcone's, and I will be handling the witnesses and so forth in this matter.
Okay, welcome aboard.
Thank you. Not having conducted a zoning hearing in this room, where do you put witnesses?
They come up and stand with you at the podium.
Okay, thank you.
Yeah, we had a pile of them. Here they are.
Mr. Chairman, do you wish to determine whether there are any other parties or people that wish to be parties before we then proceed?
We do it. But are there any other parties, any other persons who wish to be parties?
Mr. Chairman, Jim Greenfield representing the Luella Court Historic District Neighborhood Association.
Welcome, Mr. Greenfield.
Thank you. Thank you, sir.
Anybody else?
My reason for asking is that what I provided you is a packet of exhibits that will be used, and I wish to be able to present that to opposing counsel so that he had it as we move forward as well.
Certainly. Thank you.
What you have in front of you tonight is primarily an appeal from a decision of the zoning officer. As you will hear, this is a property that has an apartment building on it. We are going to be renovating the apartment building to reduce the number of units. With the reduced number of units, we can create compliant parking, but the zoning officer has determined that since we're housing those spaces in a garage, and the only garage on the property presently is a two-car garage, that we're expanding somehow a non-conforming use by creating conforming parking on the property. And so that's what this is about. And my first witness is Caswell F. Holloway III. Why don't you go to the podium?
I do. Caswell F. Holloway III.
And Mr. Holloway, what is your business?
C.F. Holloway III and Company is a builder-developer.
And what is your position in that company?
I'm the president of the company.
Okay. Now, you have in front of you a packet of exhibits, is that correct?
Yes.
Okay. Would you look at Exhibit A2? A1, by the way, I've marked as the application. I don't intend to present any testimony in regard to that. It was filed with the board. What is Exhibit A2?
Exhibit A2 is the amended and restated agreement of sale between Acer Capital, Inc., seller, and C.F. Holloway III and Company, or its nominee, or assignee purchaser.
And is that for an agreement of sale between your entity and the property, for the property that is the subject of this application?
Yes.
Is it still in effect?
Yes.
You are still the equitable owner?
Yes.
Would you turn to Exhibit A7A? And what is Exhibit A7A?
Exhibit A7A is the existing conditions and demolition plan prepared by Chester Valley Engineers.
And what is the property that it shows?
It shows the...
let me rephrase that. Does it show the property that is the subject of the agreement of sale?
Yes.
Now, I notice on that plan there is a portion of the property that is a panhandle out to Route, or to Lancaster Pike. What is that? Who uses that?
That piece of the property is under an easement agreement between the current owner and Radnor Township.
Okay. And then I noticed that there is a circle, a road circle that surrounds the main piece of the property. Is that correct?
That's correct. Luella Court.
Okay. And how big is the property inside the road?
Approximately a little over an acre.
Okay. And how many lots are contained in that area?
One lot.
What is on that lot?
There's an existing building that has 25 rental apartment units. There is also a parking lot and a two-car detached garage, along with several walkways.
Yards?
There's a yard around the building and around the parking lot and to the east of the parking lot.
Okay. And that use of the property, that apartment building, does that conform with the requirements of the zoning district? First of all, what district is it in?
It's in the R4 zoning district.
And is the multiple family use permitted in the R4?
No, it's a non-conforming use.
When did it become non-conforming?
When the zoning was changed from R5 to R4.
And the apartment building existed at that time?
Yes.
Does the building comply with the height requirements?
No, it does not.
Are there setback violations of the building?
Yes. The north entrance, part of the covered porch is over the setback, and on the western side of the building, a small portion of the building and the covered porch is also over the setback line.
And in fact, if you look at A7A, the setback is shown on the plan and the encroachments into the yards are shown on the plan then, is that correct?
Yes, they are.
How many parking spaces would the 25 apartments require?
It's my understanding under the current ordinance, 50 parking spaces for the 25 units and additional spaces for visitor parking, I believe 7 or 8 additional.
And how many parking spaces are there on the present property?
16.
Okay. And if you parked in the garage and then parked in front of the garage, how many spaces would that then make?
18.
So the property is conforming or non-conforming with respect to the present parking?
It's non-conforming to present parking.
Now I'm going to ask you to go back to Exhibit 5. And Exhibit 5 has A, B, and C, is that correct?
Yes.
They're pictures?
Yes.
What is Exhibit A5A?
Exhibit A5A is a picture of the south front elevation of the building taken from the panhandle that you mentioned earlier near Lancaster Avenue.
And what is A5B?
A5B is a picture of the eastern elevation of the property, and it shows 2 cars in the existing parking lot, fire hydrant, and it also shows partially, you can see the north side elevation in perspective.
And what is A5C?
A5C is taken from Luella Court in front of the south elevation of the building, and it's looking northeast, and it shows some of the additional of the existing parking lot. It shows the detached garage, and it shows the hedge that lines Luella Court, the circle.
And that hedge that lines it defines this property from the street, correct?
That's correct.
Now, Mr. Holloway, what is it that you intend to do with this property once you acquire it?
What our plan is to realign the space, the interior space of the building, and reduce the number of units from 25 rentals to 12 condominiums, and to also refurbish the outside of the building.
Okay. Now, before we go further, A7B, would you take a look at that?
Yes.
Is that an aerial photograph of this area?
Yes, it is.
And is the large area surrounded by road in the middle of the plan this property?
Yes.
And On that, do you see the hedge that runs all along the road around the south and then eastern and slightly, and then partially across the northern portion of the property?
Yes.
And in fact, the parking and garage are also shown on there.
Yes.
Now, with respect to the renovations that you're going to make to reduce the number of units on the property, are you going to modify the height?
No.
Are you going to modify the location of the building with respect to any of the encroachments into the yard?
No.
They will remain.
Yes.
By reducing it from 25 units to 12, will the use become conforming?
We will
The
be...
use of the multiple family use, would that become conforming?
No.
Okay. How many parking spaces would be required by the 12 units instead of the 25 units?
Under the ordinance, we are required to provide 24 spaces for the 12 units and 3 additional spaces for visitor parking.
And within the lot that's used for this multiple family use, is it possible to then construct the conforming parking to remove that component of nonconformity?
Yes.
And how do you intend to do that?
We intend to construct an underground parking garage facility for the new homeowners, for the owners of the 12 units. That will provide 2 parking spaces per unit undercover, and then we will have 3 visitor parking spaces on the north side of Luella Court.
And are those shown on A7C?
Yes.
Okay. Now, with respect to the underground garage, would the extension of the side walls of that garage, if they were above ground, be within the building setback, or would they encroach upon the yard?
They would encroach upon the yard.
Okay. In May of this year, did you request from the zoning officer an opinion with respect to the ability to reduce the number of units and the ability to build the underground garage?
Yes.
Did that request include a request as to whether any zoning relief would be required?
Yes.
And I direct you to Exhibit A3. And what is the letter that is A3?
This is a letter from Mr. Matt Bauman, the zoning officer. And the first paragraph states that the change from an apartment house use where dwelling units are rented to a less dense condominium building where dwelling units are purchased is a continuation of a valid, non-conforming residential multifamily use in the R4 district.
And with respect to the second paragraph, did he opine on the ability to build an underground garage that would in part be below the required yard areas of a building, of the lot?
Yes, and I quote, "As to the construction of underground garages, it is further my opinion that the construction of the underground garages will not need to conform to the setback requirements in the R4 district based upon the definition of front yard, side yard, and rear yard in Section 280-4 of the zoning ordinance." And also, he goes on to say, since the garages will be underground, these areas will remain open space, and there are no separate setback requirements for underground facilities.
Now, did you take any appeal from his letter of June 3rd?
No.
In fact, you concurred with his opinion of June 3rd, did you not?
Yes.
Did his letter of June 3rd fail to address any of the questions that were raised in your initial request for his opinion?
In our initial request, we also asked if there was any zoning relief required to construct the underground garage.
And I direct your attention to A4. Did you subsequently receive A4?
Yes.
And what does A4 say? I would ask you to go specifically to the, in summary, at the end of the first paragraph.
As to the construction of underground garages, it is my opinion that the construction of the underground garages will need a special exception under Section 280-101A 2 of the zoning ordinance because these garages will be an extension of a non-conforming use. In summary, there exists a 2-car garage with the intent to construct a 12-car garage, which increases the non-conforming use.
Okay. And in fact, you're not asking to construct a 12-car garage, are you?
No, we're asking to construct a 24 underground covered garage.
Okay. And the 2-car garage, is the 2-car garage a non-conforming use within the district?
No.
Now, in furtherance of your application, did you proceed to the Radnor Township Historic Architectural Review Board?
Yes.
And I direct your attention to Exhibit A11. And did you receive a certificate of appropriateness from the review board and the township?
We received a recommendation for a certificate of appropriateness from HARB, and then we received the certificate of appropriateness from the Board of Commissioners.
Okay. And I read on A11A, demolish existing garage and build 124-car underground garage with trash room, ramp, and steps attached to the existing building. Was that the application?
Yes.
And that's this underground garage we're talking about?
Yes.
And A11B is from a letter from the township solicitor, is that correct?
Yes.
And does that date with the relate to the action taken by the Board of Commissioners with respect to the certificate of appropriateness?
Yes.
And did they modify the recommendation from the HARB?
Yes, they asked us for a 3-foot reduction in the height. They asked us to lower the building by 3 feet at the east end of the parking garage.
Lower the already in-ground building?
Yes.
So that would increase the amount of area above it, ground above it?
No. It was actually going to lower the profile as it related to
the grading.
The grading, yes.
And so it was approved with that modification?
Yes, it was.
And are your plans then consistent with Exhibit A11?
Yes, actually, our plans exceed 3 feet, and we lowered the building more than 3 feet.
And I'm going to ask you what Exhibit A8 is, if you would turn to that.
A8 is a design concept plan that was prepared by Gordon Eady and Associates, our landscape architect and landscaper, to give a visual of what the area above the underground garage would look like.
Okay. And so that A8 shows what your lot would look like from above upon completion of the renovation.
That's correct.
Mr. Holloway, how many uses are there of this property?
One,
What is that use?
multifamily use for 25 apartment units.
And how much of the lot does that use encompass?
The entire lot?
There's no other use of any other part of the lot?
No.
Okay. And when this is done, how many uses will there be on the lot?
One.
And will there be any other uses that are on any part of the entire lot?
No.
Will any part of the lot that is not used for the current use be used for the current use?
Could you repeat that?
I just asked you a rhetorical question since you told me there was only one. I just wanted to be sure you were saying that are you saying that there will be no part of the lot used for the multiple family use that is not currently used for the multiple family use?
Yes.
You've been to the Shade Tree Commission for approval of this?
Yes, we have.
You're in front of the Planning Commission?
Yes.
Okay.
We've had 2 meetings before the Planning Commission on this application.
I have no other questions of Mr. Holloway.
Do any members of the board have any questions for Mr. Holloway?
I have one question.
Yes, sir.
Is this underground parking structure going to be attached to the building?
Yes,
Now,
it will.
By saying that, I don't mean necessarily with walkways or steps, but the actual structure is going to be married together? Will they be tied in together?
Yes,
They will be, okay.
at the basement level. At the basement, actually, the underground garage is 2 feet lower than the existing basement of the building, and then it drops off approximately, I think 3.5, 4 feet away from the building. So the garage gets steeper as it moves away from the building.
But I mean, the actual structural, they'll be tied together.
There is a connection point, yes, and that's shown. Yeah, it's connected with stairs and a ramp for wheelchair access.
No, I understand that, but I mean, the actual structures, are the structures attached? I mean, it's normal for buildings to be attached by, stairs and walkways, but are they actually structurally connected, is what I'm saying? Because I think that has an effect under one section of the code. That's why I think it's relevant.
When you say structurally connected, it's attached to the existing
I mean, sometimes you
structure.
take a building and you structurally attach it to another building so that it's an uninterrupted structure, and sometimes they're separate and they're just attached together by walkways or stairs.
Yeah, the garage itself, there's a 10-foot wide connection point that separates the garage itself to the existing structure, which has the ramp and the steps that'll...
I mean, when it's all built, if we knock down the underground structure, would it affect the house, the main building?
No.
It could stand. And if we knock down the main building, would the garage still stand?
Yes.
Okay. All right, then I think they're really not connected for that purpose. They're just linked by communication, by a way to walk, right?
Yeah, they're not, I didn't know what you meant.
And
They're independent structures.
Yes.
yeah, they're independent structures,
Okay.
and that was not the nature of the opinion that we're appealing anyway. It was
Right.
that we were
No, I think it has
expanding the
another
garage.
It has another implication under the code, so
Yeah.
I think it's just important to know that. Okay, thank you.
Mr. Holloway, no portion of this garage will be above ground. This garage is entirely underground.
It's entirely underground. You do have the access of the door access, and there's also an emergency access of a door that egresses out. But both of those doors are behind the setback line.
Any other members of the board have any questions?
Yeah,
I have one more question. I'm not sure who your other witnesses are, so maybe, Mr. Holloway, you may not be the right person to ask this to, but I will, and you can defer to another witness if you'd like. The corners of the garage, of the underground structure,
Yes.
the new one, are they going to be at least 3 feet away from the property line at the corners?
Well, the property line,
It's hard to tell on the plan of this scale. I don't think that distance is...
yeah. Yes, yes.
They will be? Okay.
Yes.
Yes. Thank you.
Mr. Greenfield, did you have any questions for Mr. Holloway?
Thank you, John. I do. Some of the questions that I have may be more appropriate for an engineer, so I guess I'm wondering whether there's going to be any engineering testimony on behalf of the applicant.
Yes.
There will be. Okay. Thank you. That'll help me streamline this a little bit. Mr. Holloway, is it fair to say that the parking that currently exists on this property is accessory to the multifamily use?
I'm not sure I know what you mean by accessory. It's the parking that's on the property is specifically for the building.
It's there to serve the current tenants, right?
Yes, yes,
And it's your contemplation that the parking that you're going to construct will serve the owners of the condos?
yes. And there will be 3 visitor parking spaces that will serve the building also.
Now, if I have questions about dimensions of various items on the property, both existing and proposed, I should better ask that of the engineer?
Yes, I'll try to answer if I can.
Okay, well, let's see what we can cover on that. Do you know what the current elevation, the current highest elevation of the parking area on the property is?
Of the parking area or the parking, the existing garage? Or?
The grade level of the existing parking area. And if you could tell me what exhibit you're referring to, I'd appreciate it.
It's anywhere from 101 at the entrance, 100, 99. I can't read all the dimensions.
Are we
Yes, I'm looking
referring
at
to an exhibit?
A7A, which is the existing conditions and demolition plan.
And do you know what the elevation, the highest elevation in the parking area is going to be post-development?
The highest area, well, the actual parking garage floor is going to be, I believe, 88.
The garage floor?
Yes.
What about the area above the roof that you're going to be landscaping? What's going to be the highest elevation there?
Well, it's going to be at grade level, at the existing grade level at the curb, and I believe the highest point is going to be around 102.88 approximately, maybe 103. But I'm happy to let my engineer answer that too.
Well,
if I'm not.
Let's try to save most of those questions for your engineer.
Okay.
The garage that you're going to build is going to have a foundation, correct?
Yes.
And it's going to have support beams?
Yes.
It's going to have 4 walls?
Yes.
And it will have a roof?
Yes.
And it'll be a permanent structure, correct?
I hope so, yes.
And when the construction is finished, and this is the garage we're talking about, will the north, east, and south sides of the garage be within 15 feet of Luella Court?
I'd have to, I can't answer that
So
question.
that's an engineering question?
Yes.
Do you have a plan in place at the current time to control erosion and sedimentation for the excavation on this property?
We have not submitted our land development plan. We were told we had to go before this board before we could do that.
And do you have a plan for stormwater management in place yet?
It's under development with our engineer, yes.
You familiar with the impervious calculations for the property?
Yes, generally, yes.
What's the current impervious on the property?
Mr. Chairman, I don't believe any of these, I've stepped back for a while, I don't believe any of these are relevant to the question of the appeal of the zoning officer's determination. The question is whether it's an expansion of a non-conforming use or not an expansion of a non-conforming use. And the issues that Mr. Greenfield's talking about are all related to land development plan approvals or approval of a plan sometime subsequent to this.
And you're not seeking any relief with respect to impervious or anything
No.
like that?
No.
Okay. Jim, did you have a lot more on that, or?
I don't have a lot more on that. I am going to have a few questions that may more appropriately be directed to the engineer. But we think impervious is an issue because health, safety, welfare is always an issue on any special exception or variance application.
Okay, then, if you wouldn't mind, let's save them those questions for the engineer.
Okay, I'm happy to do that.
Well, can I just ask Mr. Holloway something on that issue?
Yes.
Are you going to increase the percentage of impervious cover?
No, we're going to reduce it.
Okay. So it's not going to increase what's there now.
Mr. Holloway, when you say you're going to decrease impervious, that's based on...
I said reduce. I said reduce.
Reduce impervious. That's based on your assumption, is it not, that no part of the garage is to be considered impervious?
It's our understanding that what the green roof is considered pervious.
So again, your view is that the entire garage has to be considered as pervious, correct?
The yard area that is above the garage roof is pervious, yes.
And what's...
I think probably ought to save this sort of stuff for the engineer.
Okay, happy to do that.
Excuse
me just a moment.
Sure.
That's all we have for Mr. Holloway at this time.
Okay.
Thank you.
Thank you. My next witness is Angelo Capuzzi. Yeah, just leave that.
I do.
And just state your name, please.
My name is Angelo Capuzzi, C-A-P-U-Z-Z-I.
And Mr. Capuzzi, what is your profession?
I'm a registered civil engineer and land surveyor in the Commonwealth of Pennsylvania.
And I direct you to A9 in that packet in front of you. And would you tell the board what that is?
That's my biographical sketch, my resume.
Have you testified in front of zoning hearing boards in the past?
I have.
This zoning hearing board?
Not in the last 35 years.
Okay. The information in Exhibit A9, is that true and correct with respect to your background and experience?
Yes, it is.
Mr. Greenfield, do you have any questions you want to ask of Mr. Capuzzi with respect to his qualifications?
We have no objection to Mr. Capuzzi's qualifications as an expert.
Thank you. Does anyone on the board have any questions about Mr. Capuzzi's qualifications? Okay.
Let's turn to A7, Mr. Capuzzi. Were those plans prepared by you?
Yes, the plans in Exhibit A7 were prepared by Chester Valley Engineers.
Okay. Now, those plans don't show height, do they?
No, they don't.
Okay. But with respect to the nonconformity as to the location of the main structure, those are shown on your plan?
Yes, the building location is based on surveys that we performed.
Okay. And with respect to the amount of parking on the property, do you concur with the existing nonconformity with that?
Yes, the extent of parking, again, is based on field surveys that we performed.
Okay. You've indicated to me in the past the possibility of a different nonconformity. Would you explain what that is to the board?
Yes, Section 280-104D of the zoning ordinance requires a loading area for buildings in excess of 5,000 square feet. It's supposed to be a separate off-street loading area. This property does not have such an area. If the parking lot were used as a loading area, that would reduce the amount of available parking within the parking lot.
So, in your opinion, you either have a nonconformity of lack of loading and the parking that was testified to before, 16 or 18 spaces, or you have a larger nonconformity with respect to parking, namely less than 16 to 18 spaces, because some of it would be loading and unloading.
Correct.
Is any of that parking lot lined?
No, it consists of a macadam driveway with broken macadam and gravel for the parking areas.
Okay, so you couldn't tell whether it was loading or parking if you went out and looked at it?
No, or neither could we can confirm that the parking spaces meet the township requirements for length and width.
Okay. Mr. Capuzzi, the area of the property that is devoted to the non-conforming use, can you tell me how big that area is?
It's roughly 44,300 square feet.
Do you have an actual number?
44,321 square feet.
And once the plan is approved and the changes are made by Mr. Holloway, what will be the area of the lot that is devoted to the non-conforming use?
It will be slightly less by about 1,700 square feet. Part of our improvements include the construction of a sidewalk around the perimeter of the property. There currently is no sidewalk in the area, and part of that sidewalk will, based upon the configuration of the roadway, will fall behind the existing right-of-way line. So we'll have to carve out some pieces of right-of-way in order to construct the sidewalk so we can dedicate them back to the township.
Will there be more or less impervious surface on the property after the project is completed?
There will be less impervious surface on the property.
And why is that?
We're removing the existing parking lot primarily is the reason why.
Yeah. And from the definition of impervious surface in this township, why does the area above the garage, the green area that is shown above the garage on Exhibit A8, why is that not impervious because of what's below the surface of the ground?
By definition, it's a surface that absorbs water.
Were you at the Planning Commission meeting last week or earlier this week?
Yes, Tuesday night.
Was that question raised?
That question was raised by the Planning Commission, and the township solicitor at the time read the definition of impervious surfaces and concluded that this does not qualify.
I object to this. Whatever occurred at the Planning Commission meeting stands for itself. There may be a videotape record of it, but it's clearly hearsay for this witness to try to relay what was said by other people at that meeting. I think it's inappropriate.
As a result of that question being raised, were you required by the Planning Commission in that meeting to provide for stormwater management as if that area were impervious?
The Planning Commission expressed concern about the amount of runoff in the area. They indicated that the Wayne area experiences flooding problems and they asked us to take a hard look at how we deal with the runoff from that area. So the question, I guess the answer is yes.
Yes, you were required to consider that as impervious?
We were required to consider it more so than it would be just lawn.
Can I ask a question? Will you be involved in the stormwater management design phase for this project?
That was my next question.
I will, yes.
Carry on.
Will you be involved in the stormwater design phase for this project?
Yes.
And has that stormwater design been completed?
It has not.
And when would that be completed?
We would complete that along with our application for preliminary land development approval.
Have you preliminarily looked at the site to determine whether with these improvements you can provide adequate stormwater design?
I believe that we can provide adequate stormwater design. I've reviewed the township ordinance. I know what the criteria is for the design. I believe we can meet both the recharge requirements and the expanded rate control requirements that the Plan Commission asked us to look at.
Your intention is not to ask for waivers of those?
No.
And who reviews those, your compliance with those?
They would be reviewed by the township engineer.
And who would approve the design of those?
Eventually, the Board of Commissioners.
Okay. Thank you. You heard Mr. Holloway's testimony about the location and the fact that the only parts of the garage on this property that would be above ground would be the two entrances. Is that correct? You heard that testimony?
Yes, I did.
And do you concur with that?
The garage door and the pedestrian emergency exit point would be visible from the street, yes.
Okay. I have no other questions of this witness.
Do any members of the board have any questions for Mr. Capuzzi? No? John, do you have any questions for him? No? Mr. Greenfield?
Thank you. Mr. Capuzzi, I believe I heard you say that the amount of property currently reserved for the existing use is 44,321 square feet, correct?
Yes, that's what I said.
That's the total area of the property, is it not?
No.
Tell us, please, what that encompasses.
That 44,000 figure encompasses basically the island created by Luella Court.
Okay, so
It doesn't include the strip going out to Route 30.
it does not include the
No.
what we've referred to as the peninsula.
It doesn't include the access strip to Route 30.
Okay, thank you. That's a much better way to phrase it. With regard to the island that's fully surrounded by Luella Court, is every square foot of that island currently being used either for multifamily or for parking?
That is one continuous lot which has an existing 25-unit multifamily residence on it.
There are portions of the property, particularly to the east, where there's no use, there's no parking, correct?
There is open space to the east of the existing parking, that's correct.
And there are no dwelling units on the eastern end of the property, right?
No.
And there are also green areas around the building itself, correct?
Yes.
Particularly in the yards to the extent that they exist, right?
Yes.
Now, with regard to your testimony on the the green roof. Is it correct that you testified at the Planning Commission the other night that there is a difference in the runoff coefficients for pervious and impervious?
I did say that.
And what is could you tell the zoning board, please, what that difference is?
Generally speaking, the runoff coefficient for impervious surfaces is 95%. For lawn areas, it varies between 25 and 30%.
So that means that for impervious surfaces, 95% of the water that hits it will run off, correct?
Correct.
And for pervious surfaces, that number would be 25 to 30%, right?
Generally speaking, there are cases, especially in some of this recent weather we had, where the ground's saturated. You may get a higher rate of runoff from lawn areas because the ground can't accept any more water.
Now, what's going to be the square footage of the roof of the proposed garage?
I think it's about 9,300 square feet. I'm sorry, 9,800 square feet.
9,800 square feet. And the current parking area, including the two-car garage, is substantially less than that, is it not?
I believe it's about 5,400 square feet.
And have you observed whether the garage has been used for parking purposes?
I have not.
Okay. What's the square footage of the garage in terms of footprint?
I believe it's about 430 square feet.
So if you take that out, then we're talking about less than 5,000 square feet currently devoted to parking on the property?
That's correct.
So essentially what Mr. Holloway is proposing to do here is double the surface area devoted to parking, right?
That's true.
Now the green roof, as proposed, would be how thick? In other words, how much dirt and grass on top of the roof?
12 inches of soil above the finished grade of the garage roof.
Now, you were asked at the Planning Commission the other night whether the 12-inch thick green roof would be closer to a pervious or an impervious surface in terms of its runoff coefficient. Do you recall that?
Objection. You didn't relate it to the ordinance. You related it to runoff coefficients, which is... My objection is that it has no relevance to this proceeding. He asked the question of whether it would have its relationship to runoff coefficients as opposed to its relationship to the definition of impervious surface in this ordinance, which is the only relevant thing in this township. It might be a nice academic question, but it's not a relevant question, even in the land development process.
It's definitely a relevant question because there is an issue as to whether this proposal is in compliance with the township code regarding impervious surfaces. And there is a parallel health, safety, welfare issue regarding the ability to control stormwater on this property. We recognize that there has not been a fully engineered plan submitted to the township yet that would show stormwater, but given the way that this project is laid out and the amount of space that will be left outside the proposed garage between there and Luella Court, there's a legitimate question before the board as to whether stormwater is going to pose a health, safety, welfare issue that the board should be aware of.
No, did you have a comment you want to make?
Well, yeah, maybe we can cut through some of this. You're saying, have you said, I think, in your professional opinion, that there will be no increased runoff when this project is done versus today, existing conditions?
I said that the post-development rates of runoff will be in compliance with township code.
Yeah. Will they
In which
be
case, they will be no greater than existing.
existing? Okay. And in your professional opinion, this is not an impervious surface, this area of the new garage, underground garage?
based upon the definition in the Township Code, it doesn't count as impervious surface.
Okay.
If that's the issue, then I would like to be able to explore that a little bit, because if this garage is in fact closer to being impervious than it is to being pervious, then it's a structure. And if it's a structure, then it has to observe setbacks.
Well, I don't know that I agree with that under our code, but that's
Well,
either
not
for
only,
another day.
not only that, Mr. Cutler, but the opinion of the zoning officer as of June 3rd opined that it didn't have to meet those, and no appeal was taken of that. And everybody was more than aware of those opinions. They were disseminated by the township. So from the standpoint of that issue's gone. The township has taken the position that if it's underground, it doesn't meet the definition of an encroachment into a yard, and therefore we don't have to meet that.
Okay, before we start summarizing our arguments, I just want to, are you intending to put on any engineering evidence?
No.
Okay.
That's why I'm asking these questions.
Now,
to this witness.
so the questions I've asked him now, is there anything else that we didn't cover with regard to stormwater? I mean, he doesn't have a fully studied plan, so we can't take him much further, but is there a point you want to make on the engineering that
The point on stormwater, which is the point on impervious, is the same point that he was asked to make the other night before the Planning Commission, which is where in the range of coefficients between pervious and impervious is this roof likely to fall?
I don't think that's an issue under this zoning ordinance, though. It's either an impervious surface or it's not under the definition. And, you know, how close is it? You know, is it this way or that way? We have no basis to make a decision on that. There's no standards in the zoning ordinance.
Even a pervious surface, as the witness has just testified, doesn't absorb all the water that falls on it.
But
Right.
aren't we stuck with what the code says?
And the matters of land development will be dealt with by the appropriate township officials. I mean, this is not a pass to do whatever they want for all purposes. This is a very narrow issue of zoning.
Well, look, I think there's a question here as to whether the zoning officer was given adequate information when he made his ruling that setbacks don't apply. And that was not a legal opinion. It was an engineering opinion based on the facts that were before him at that time. Part of this whole thing is to determine whether that was accurate. And
Are you
whether-
calling the former zoning officer to testify?
I can't, no, I'm not calling him to testify.
In addition, we did not appeal that letter. That letter is not in front of you. That letter wasn't appealed by anybody.
Now, I'm not so sure for other reasons that the letter's even relevant, but
Was the letter, was the notice given, was there a publication of notice that the letter, that the opinion had been received, et cetera?
It was not treated as a preliminary opinion. The
Okay,
township
that's my
gave
question.
copies of that to the various parties
So
in
they had actual
interest, so they
notice.
had actual notice.
Okay.
I do think
In
that-
addition, even if sometime down the road, somebody rules that this top, the area above the top, is impervious under your township ordinance, which so far nobody has done, and everybody has opined the other way, that would just mean that at that point in time, we couldn't go forward. It
they
has
won't
nothing
get
to
land
do with
development
this.
approval. They won't get land development approval unless they can meet those issues.
Well, also the
So
other...
the garage will never be built.
Well,
No, the other point is that, you know, we are generally quite narrow with our decisions. We restrict them to what is before. I've not heard a request for any relief from impervious. Now, that doesn't prevent the board from, you know, we've also had plans that come in, somebody says special exception, and you take a look at the plan and know that's clearly a variance. But we don't, you can also, if the board were to feel that this is, you know, not impervious, and I see difficulty as how that inquiry could be pursued right now based on the testimony we're receiving. But the board also, if it were to approve this, could exclude any opinion about whether this is impervious, about impervious coverage or any other dimensional requirement. And I assume, Mr. Snyder, that the applicant would have no issue with that.
We couldn't.
Okay. I mean, all we're here on is it an expansion of a non-conforming use or not?
Well, it's two things. One, if it is, they want the special exception. And they're saying first that the zoning officer was wrong, that this is not an expansion of a non-conforming use.
Okay.
And secondly, that if the zoning officer is right, you're applying for the special exception.
Right, okay.
So the board's ruling on the objection is?
I don't think, I think that we're going to, because the question is use, the issue of the impervious isn't before us.
So you don't want to hear any testimony on the impervious whatsoever?
I don't.
Not on this application today. Right?
Okay.
Yeah.
Mr. Capuzzi, you'll agree with me, will you not, that the proposed garage is a structure?
I believe it meets the definition of structure.
And it also meets the definition of building, does it not?
I believe is the definition 4 walls and a roof.
Basically, yes.
It is? I mean, each township is a
Excuse
little
me,
different.
right now,
and 4 walls.
the witness is guessing based upon,
Yeah.
if you want to show him the ordinance.
Let me ask him,
we can
based
read
on
it.
his understanding of the ordinance, whether this is a building.
I don't think his understanding is relevant when we have the ordinance in front of us. Let's read it.
Yeah, I think that that's the ordinance is the best proof.
It is what it is. It speaks for itself. Would you like me to read it, or would you like to read it, sir?
I have it.
Okay. We'll read along with you.
Okay. Any structure having enclosed walls and roof permanently located on the land. A vehicle built for living or camping, right, that doesn't apply. So I would say, yes, it's a building.
And would you say it was,
No, it's a structure, but it's not a building. Because the structures are on, in, or under the land, where this has to be on the land to be a building. Under this, it has to be on the land. If you look at the definition for structure, I mean, we want to get it right since we're going by facts here. Look at the definition for structure in the same code. There it talks about any man-made object having an actual stationary location on or in land or water, on or in. This one just says on.
Mr. Cutler, I think the witness has already testified that he thinks it's a building.
Well, the code is the code. I don't care what he thinks it is. The code speaks for
Oh,
itself.
I understand, but the witness is entitled to put his testimony
Right.
into the record.
No,
I
But this is
understand.
not engineer. This is not engineering issue.
Yeah,
This is
gentlemen, we don't need to debate the
Yeah.
question. Let's move on.
Excuse me a second. Mr. Capuzzi, what's the square footage of the footprint of the existing mansion?
We have it about 7,600 square feet.
And that's not going to change as part of this, as part of the proposal?
No, and that number does not include the porches on the 3 sides. With the porches, it's closer to, I believe, 9,000 square feet.
With regard to the elevations, I'm sure you were present when I asked Mr. Holloway those questions. What's the existing highest elevation in the parking area to the east of the mansion?
Elevation
Of grade.
Yes, elevation 101.
And what will be the highest elevation after development?
Within the parking area, I believe 102.5. There will be a slightly higher elevation at the entrance into the garage where the doors are. It'll be about a foot higher than that.
Okay, and the northeast and south sides of the proposed garage will be within 15 feet of Luella Court, is that correct?
I believe so. I could have to scale that to be sure.
Would you take a moment to do that?
Sure.
Thanks.
Mr. Green, While he's looking at that, I'd ask the relevance of that question.
Is that directed at me or at the board?
Yes.
Is that an objection?
I'm objecting to, as to relevance. I'm not sure what the relevance of 15 feet is.
If this is a structure, it needs to observe setbacks.
Well, are you suggesting that the setback is 15 feet?
No.
Okay.
The structure is closer than 15 feet in the northeast and southeast corners to the right-of-way line.
And the required setbacks on that portion of the property are 30 feet, is that correct?
The front yard setback in this zoning district is 30 feet, that's correct.
Right, and what you have here in effect is 3 front yards, north, east, and south, right?
And actually west also.
I'm going to object again. We're back into the issues of the June 3rd letter, which was not appealed and are not a part of this application.
It's already been answered and it's in the record. These letters were raised by the applicant as being relevant documents.
Yeah. Jim, I have to say that I'm not sure how this is relevant to the application.
Well, I think the evidence is in, and certainly when it's time to argue this, I'll be happy to link it.
I think that there's not only the issue of whether that letter should have been appealed, but what is the setback that for the principal's building or an accessory structure?
Right. If it's accessory, it's only going to be 3 feet, right?
Correct.
Is it within 3 feet?
No.
It's
It's
further distant than 3 feet.
yeah. We asked that, and Mr. Holloway answered that. That's
Well-
more than 3 feet away.
We're also talking about parking in the front yard, which is another issue.
Actually, I think there's a strange issue under the code there, because this is not a corner lot. This has 4 frontages.
It's a wall-round lot.
Yeah. So, I mean, does it have 4 front lots? I mean, our code never says what to do in a case like this. It said it would have two front yards.
Look, I would
That's
also...
for a corner lot.
That's right, but the code never deals with any other situation.
Well, I think we all know that they
So we-
occasionally exist.
So we have a front of the building, and the only thing reasonable to do is probably to say, well, then what isn't the front or 2 sides and the back?
I also would...
I don't think so. You have 4 sides of this.
There's at the very least an ambiguity, so we're going to have to decide how to resolve it if there's an ambiguity.
I don't think there's an ambiguity.
What is your advice?
Well, on the yard issue, you have to look at the definitions of yard. The overall definition is required open space around the periphery in which no building or structure can be located. But then it goes on in the definition of each individual yard, and it says that the minimum open space, full width of the lot parallel to any structure, principal, accessory, or other on a lot. Is this on the lot or is this in the lot? We notice that structures elsewhere in the code use a definition of in or on. Buildings and above-ground structures are on, but the yard operative definitions of all the yards talk about on a lot, and when tied with open space, I read that as meaning that as long as the space is open, you can have stuff, you can have a structure below ground. I think there's at least a very strong argument to be made for that proposition.
And that was what was in Mr. Bauman's letter of June 3rd, which nobody took any action against.
I think we'll decide that's perfect decision.
That was exactly his finding.
Yes.
Let me ask the witness if this plan has changed since June 3rd.
No, we submitted the plans, I believe, to the township on August 15th.
Okay, and was there anything different about the garage proposal on August 15th than there had been before June 3rd?
We made the garage 4 feet shorter in length. We changed the elevation at the eastern end based upon comments we had about the grade at the eastern end. those are the two things that I can recollect right now. I mean, the width of the structure didn't change.
But the dimensions changed somewhat, correct?
The dimensions got smaller. They got shorter, yes.
It seems to me that we're faced with a legal and factual determination that needs to be made by the board as to the meaning of this letter. It says, since the garages will be underground, these areas will remain open space, and there are no separate setback requirements for underground facilities. It doesn't matter. I mean, what the letter says, the June 3rd letter, is that yards don't apply if it's underground.
Right.
Now,
And that letter wasn't part of the appeal.
Right.
And that's not the issue in front of you in this hearing. Nobody appealed that.
Well, that's the point I'm making. It doesn't say that it's the yards don't apply if you're 7 feet away, but it's tied to a specific foot. It just says they don't apply.
Yeah.
And that's what the letter says. Now, to the extent that the board were to, find that there isn't an element of time bar, that's a determination for the board. They've had testimony on that, but in terms of what the letter purports to say, it says you do not need yards for an underground structure. And it doesn't give any, I don't see any guidance in that or limitations on certain distances from the end of the property. It just simply says you do not need a yard for an underground structure.
Okay.
I think there's a question as to whether that letter was an appealable event. I mean, there's question as to whether there was adequate publication of it.
I think that the date of when it came out is certainly relevant. I mean, as in another case that we were involved in, if it shows up in the file in June and nobody hears about it until late October and an appeal is filed in early November, I don't think there's a time bar.
Right.
But again, I don't know when this, have we had testimony as to when this letter became generally known?
No, because it's not relevant to this application. If Mr. Greenwood's client wants to try to take an appeal from it, alleging that they just found out about it tonight, that's his option. I don't think he's going to be able to sustain that given the dissemination by the township solicitor. But that's not in front of the board tonight. That's a whole separate case if Mr. Greenwood wants to try to bring it. But this is our application. Our application deals with the determination in the June 10th letter and the June 10th letter only.
Well, you would agree that any determinations, that we would would not affect the appealability of that letter, I guess.
That letter isn't in front of you, so obviously all you're deciding on is the June 10th letter.
Well, I respectfully disagree. I think it is in front of you, and it was raised by the applicant as part of the factual basis for its appeal.
Mm-hmm.
So it is before you. Isn't it correct, Mr. Capuzzi, that the plans that were in place prior to the end of July called for an 18-inch thick green roof on the parking garage?
There was discussion that the roof of the garage was going to be flat, so in order to provide drainage on the surface of the roof, we had to create a crown in the center, which would have required 18 inches of material in the center of the garage and 12 inches at the end so that the water would shoot off in two directions.
Jim, we already talked about that. We don't want to hear about impervious.
Right. I'm simply pointing out that these plans have changed over time. And so that's the purpose of pointing that out, is to show that some of the assumptions that the zoning officer may have made in issuing his June 3rd letter and perhaps the other letters may have been based on erroneous or incomplete information.
Nothing changed in regards to the garage except for its length.
But again, the depth of the green roof did change, correct?
I was still talking about the garage structure. Nothing changed about the garage structure except
The
for its
structure
length.
itself didn't
Yes.
change? Okay, I understand.
Part of the reason we revised the grades was to address comments that we received regarding the height of fill at the southeast corner.
And in fact, the township's consulting engineer had raised a question about the slopes, right?
He did, and we addressed those.
So that required yet another change in the plan, right?
Well, we revised the plans to address the engineer's comments. That's normal practice when you're going through this type of process.
Mr. Capuzzi, do you know whether Mr. Baumann was made aware of these changes?
I do not know. I do want to point out we made one other change to the garage, not as far as its length or dimensions, but we did move the entrance of the garage from its original location in the center of the building, or roughly the center of the building, to the western end of the garage. Again, based upon concerns raised by neighbors who are concerned about traffic opposite their properties.
Okay.
Fair to say, Mr. Capuzzi, that if the garage were considered a building, or if it were considered impervious, it would change your impervious calculations?
They may change, but the definition or the decision we have right now show that it's based upon my understanding of the code and its definition. It's a pervious surface and not impervious.
Mr. Capuzzi, are the entrance for vehicles to the garage and the doorway out of the garage, aren't they both within the setback, within the 30-foot setback?
The garage doors are not, and the door into the pedestrian access door into the garage is not.
So you're saying the door itself is not within the setback, but the vestibule to the door is within the setback?
I guess if it's a covered opening, I guess is what you want to call it.
And that is within the
That's
setback?
part of the garage structure.
Which setback are we talking about, Mr. Greenfield?
This would be the 30-foot front yard from Luella Court as indicated on the plan. Which exhibit is this again?
7C.
Is that 7C?
Yes.
Is that right?
Yes.
7C.
Yes.
And both of those features of the garage are above ground, correct?
They're visible from the street.
Okay. That's all I have for Mr. Capuzzi.
Let me ask a question. When you enter the garage, do you go down a ramp into the ground? Or
Yes.
I assume so. You don't actually go into a like a piece of building that's there with dirt piled on top of it. You actually have to take a down ramp into the garage, correct?
And I have a question. When you're leaving or entering the emergency door there, do you go down a ramp?
Coming from the garage, you're going up a ramp to the street.
Okay, so from the street, it's
lower.
Is it on the same slope, or is it steeper than the driveway? Because it's lower there, right?
The garage is lower at that point, but the street is also lower.
I see.
Okay, and I would expect the ramp to be not as steep as the driveway entrance.
Okay.
Sir, I asked Mr. Holloway before if the two structures were attached, and he finally realized, I think, that what I meant, and it was no. Do you confirm that as the engineer, that they are not attached? They don't share a party wall? The garage and the building do not share a party wall?
The garage is separated from the main building by a 10-foot connecting link that houses steps and a ramp.
Right, and that's 10 feet wide, right?
It's 10 feet wide, and it gets you from the garage into the apartment building at the basement
But they
level.
don't have a party wall. They don't have a shared wall.
Well, below ground, they share a common wall, but above ground, you don't see anything. The connecting link is not a stairwell above ground, it's below ground. You go from the garage into the basement of the existing structure.
Can I follow up on that for a moment? If you look at 7C, Mr. Capuzzi, the west wall of the garage is where the 10-foot connection begins, right?
Yes.
And there's a section. I'm sorry. Let me start that again.
We're on 7C, Mr. Greenfield?
Yes. The west wall of the garage, as shown on 7C, and that's where I'm pointing right now, is separated from the east wall of the mansion by 10 feet, correct?
Correct.
Okay. So those walls are not shared. They're connected, right?
They're connected, correct.
Thanks for clarifying that.
Mr. Snyder, do you have anything further for your witness?
No, I think we've clarified that. I had the architect here, and if we needed clarification, I was going to present him, but I think that last question completely clarified the fact. If Mr. Cutler has any further question on it, I'm happy to present the architect if you want.
Much as I hate to have had him make the trip for nothing, I have no questions for him.
Okay, thank you.
I have nothing further for the witness.
Okay, and I, by the way, on the record, want to apologize to Mr. Greenfield for calling Mr. Greenwood at least one point in that process.
Happens all the time. It's fine.
Thank you, Mr. Capuzzi.
Thank you.
Okay. Excuse me, Jim. The last thing I would like to do from the standpoint of the record is to move for admission A1, A2, A3, A4, A5, A7, A8, A9, and A11. I eliminated A6, which were architectural plans, which we didn't have testimony on, and A9, which was, or A10, which was the CV of the architect who did not testify.
No objection.
Okay, thank you.
Is A12, you moved?
A12 is a memorandum, so it's not an exhibit. It was in there so that you all had a copy of it, and my paralegal put a A12 on it when it could have just been tab 12.
Okay. But it is being submitted to this board.
It was submitted to this board in advance like your requirements are, and so it was sent to the board on August 30th, hopefully distributed, but if not distributed, there's a copy of it in your
I distributed
packets as well.
Yeah, I distributed it upon receipt.
And
received when you said it was.
I guess I should wait and see if there's any other testimony before I wrap up then.
Okay, so it was A6 and A9,
A9, right?
A10.
A10.
A6 and A10 are not part of the record.
Okay. A10 is the architect's CV, A6 is the drawing. Got it. Does anyone on the board have any concerns about admitting the exhibits listed? Okay, we'll admit them then. Thank you. Mr. Greenfield, do you have any witnesses tonight?
The only other issue that we could raise through testimony is whether the existing parking garage on the property has been used for parking at any time, to the extent that that's relevant. And we have two witnesses who can testify that in their experience, which goes back in one case quite a ways, that this garage has not been used for parking since at least 2002. If Mr. Snyder will stipulate to that, I have no need to put these witnesses on.
We'd stipulate to that.
Thank you, Mr. Snyder.
Okay. Then we have nothing further.
Okay. Do you have anything further, Mr. Snyder?
I would just like to summarize quickly on my memorandum.
Okay.
Because I think that this, as I believed it would travel far afield from what the real question was or is in front of you.
So is this not your first zoning hearing then?
No, it's not my first zoning. Good thinking. I would hate to think I'm picking up this practice at this age. That one chokes me. The issue here is a very simple one, and there are two cases specifically on point. Peinecke and Marion Park. And they are both cases where the issue was what happens when you change something within the area that's devoted to a non-conforming use. And the answer was the same in both. It's not an expansion because the non-conforming use already encompasses that area. This is a singular lot, small lot, in fact, 1 acre in size. Small in the scheme of things, maybe not small in this district, but still a single lot that has been used only for this purpose for Lord knows how many years. The expansion doesn't exist. We have a contraction. We're reducing the impact of that non-conforming use by more than half the units. As a result, we're able to make the parking comply. And we're doing it in compliance with the requirements of the ordinance. We have a right to do that. The township would want us to do that, to bring that function of the property into conformance. Where the zoning officer erred was the zoning officer treated the existing, as you've heard, non-parking used garage structure as a separate non-conforming use that was being expanded by creating a bigger garage. Well, it's not being expanded, it's being eliminated. And a compliant building that is permitted in this district, a garage for parking for the use on the site, is being provided. That's exactly what Peinecke dealt with, that's exactly what Marion dealt with. They said you didn't need zoning relief because even though you were tearing down something that was a different use on the property and putting in one of those cases, parking, it meant you didn't need zoning relief because that area was already devoted to the non-conforming use. That's as simple as this case is.
Your argument essentially is if I have a non-conforming residence and I relocate the driveway, I'm not changing the non-conforming use, which is the residence. Parking is part of that.
And it's the non-conforming use of the lot. The whole lot is used for that residence. And so if I relocate within the lot that I'm using for that residence, some function of it, I'm not expanding the non-conforming use because the lot is used. Mr. Greenwood was trying to get you to think, Greenfield was trying to get you to think.
Jim, you're going to have to change your name.
That because parts of this lot are in lawn, which is in fact a requirement, we need the open spaces under the ordinance, that those spaces aren't part of the use. And that's just not what the case law is. It's very clear. I'd end by simply reminding you that if I had if this mansion, if I had $1 gazillion and wanted to live in this mansion as a single family house so that I was in conformance with the ordinance, and I had 24 antique cars that I like to drive around, and I didn't want to have this above car garage, or ground garage that I could build within the setbacks if I wanted to, and I wanted to put it underground, I could build this structure for my use as a single family residence. There's nothing about this use that is not permitted in this district. This building, this structure, this underground garage. So, first of all, it's not a non-conforming use in and of itself. And secondly, we're not expanding the non-conforming use of this single lot that's in this district. In fact, we're reducing the nonconformities on this lot. That's our position. Just lastly, if not, we think that and I'm not actually sure what it would be we would be expanding, because the parking, we're not expanding a non-conforming use because we're making a non-conforming, we're making it conforming, we're not expanding a non-conforming use. So I'm a little puzzled at how I get a special exception from what, but if I'm deemed to be expanding a non-conforming use in some way, I think I'm entitled to a special exception, because the impacts were reviewed, determined by the Historic Review Board. We were granted by the board and the commissioners the certificate for that, and there is no waiver of the requirements for us to meet any other ordinances in the construction of it. Thank you.
Thank you. Mr. Greenfield?
Maybe a little too late for me to change my name. You reach a point in life where you become accustomed to the one you're stuck with. Mr. Snyder's statement of what the law is, I think, is incorrect. And essentially, as I understood what he said, if you don't change the dimensions of the lot, then you're not expanding a non-conforming use. In essence, what he's saying is that it doesn't matter how much of the lot the use actually occupies, if you can make the claim that the use occupies the entire lot. And in this case, we've heard testimony that clearly indicates that the use does not occupy the entire lot. The zoning officer made a determination that there was going to be an expansion of parking, which he found to be a non-conforming use. And in fact, the testimony that you've heard tonight confirms that that expansion is roughly double. So to say that there's no expansion of a non-conforming use here is simply incorrect. You're having a doubling of the area of this lot that's devoted to parking. Now, the fact that the applicant has acknowledged that the garage is going to be a separate building is significant, because if you look at 280-101A3, it says, where a non-conforming use is conducted entirely on an unenclosed premises, no structure to house or enclose such use, whether or not such structure would otherwise conform to zoning regulations, shall be permitted to be erected on the premises. Now, I don't think we have any argument on the record that this garage is going to be, at the very least, a structure and, in all likelihood, a building. Because it is an entirely separate building and it is replacing a non-conforming, unenclosed use, which is parking, then what the applicant wants to do with this garage is flatly not permitted by A3. So that's a critical point. Now, with regard to the yards, there's nothing anywhere in the definition of yard in the code that says that if you have a structure or a building that is below ground, that somehow exempts it from yard requirements. There's no distinction between above ground and below ground structures. And here you have a structure that very clearly is within the setbacks, and in fact there's been testimony from the engineer that some features of that garage are above ground, visible, and within the setback. So we have an issue with that as well. It's very clear that that the applicant proposes to increase the non-conforming use by something greater than 50%. So to the extent that you're applying that section of that portion of 28101, then there's a violation of that too. And what they would require then is a variance, not a special exception. And we've heard no argument for a variance. So I think that if you take a close look at the code, it's clear that what they want to do is not permitted here. I think the fact that the garage is a separate building is dispositive and brings this case firmly under A3. And on that basis alone, you have grounds to reject the application. If you want to take the analysis further, you can find grounds on other portions of 101 to knock it out.
I would advise the board that if the board were to conclude variance relief is appropriate, we're not in a position, the board's not in a position to grant that because it's not been advertised as such.
Just one little
Mr.
bit
Snyder,
of
yeah.
rebuttals, because he raised something that I think is clearly a red herring. And by the way, I would agree. We haven't asked for a variance, so
It would have to be published.
it would have to be published. So
A variance that we gave you that wasn't published would be vulnerable forever.
And we keep, our opposition keeps stumbling on their failure to define what the non-conforming use is here. The non-conforming use is the multiple family use of the lot. It's not parking, and in fact, we're making the parking conforming. And the paragraph he talked about, which talked about whenever a non-conforming use of land, premises, building, I'm sorry, I'm skipping down one. Wherever a non-conforming use is conducted entirely on an unenclosed premises, no structure to enclose it will be permitted. Well, I do believe that building that's sitting out there is an enclosure of the non-conforming use. And that we're not involved in a place where there was an entirely unenclosed non-conforming use. So, to us, the problem was that Mr. Baumann considered the garage building, and if you read his letter, it's very clear. He considered the garage building to be a 2-unit non-conforming garage building, and that we were enlarging that to a 12-space garage building, and that's what he found to be an expansion. The garage building was not a non-conforming use. The non-conforming use is the multiple family, and that's not being expanded, it's being contracted. Thank you.
Thank you. Jim, did you have a rebuttal?
Yeah, very briefly. I'll wait till Mr. Snyder's finished.
I'm sorry, I was just pointing out that A1 did in fact mention a variance. A1, the application
Oh, I see.
did.
Okay.
Okay, was that advertised as such?
Yes. No, sorry.
No,
At the end, yep.
it is.
A
It is.
variance from requirement of section
Yes.
28101. Yep.
Okay, so the variance request would be properly before us.
And it is before you.
We obviously don't think you get there.
It's not possible to make the parking entirely conforming because you have what is in essence a non-conforming use on the property. It's not going to change. I mean, if certainly with regard to the use of the mansion, that's not changing, and the parking basically exists to serve the mansion. But the zoning officer found, and I think reasonably, that the parking was a separate use that had to be evaluated as such. And while his letter does not indicate the basis for that, it's certainly possible that he had before him a plan that showed the garage as a separate building, which was the basis to make that determination. Furthermore, with regard to the notion that the two-car garage was part of the non-conforming use, we've pretty much taken care of that because we now have a stipulation on the record that at no time since 2002 has that two-car garage been used for parking. So it is not, by definition in the code, a non-conforming use. It's been discontinued for more than 12 months. So that issue also is taken care of.
We're not going to take public comment regarding this matter. Is there anybody that has any? Mr. Schneller. Mr. Schneller, and anyone who wishes to come up to make public comment, please limit your comments to the question before the board, which relates to expansion of an alleged non-conforming use. And we've already ruled that we do not want to hear about impervious cover. Stormwater issues, any land development issues will be developed and dealt with at that time, and it's not before this board.
Shall I speak now?
Please do.
Would you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
I do.
State your full name, please.
James Schneller. I wanted to point out that notice is confusing to the layman. I had no idea what was on the agenda tonight, and I thought that could be improved by the board generally and in regard to this, and perhaps it is insufficient.
Okay. Thank you, Mr. Schneller. Any other members of the public? If you'll be sworn.
Sir, raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, nothing but the truth?
I do.
And state your name, please.
Baron Gemmer, Baron Gemmer. Just a quick point regarding the difference between the plans that were originally submitted. The entrance that you saw, the pedestrian entrance for safety, if you look at not the door, but the walls that are right outside that door, which are still the walls of the structure itself and not retaining walls, per the code 28109, that you're not allowed to have walls in the front yard setback in R4, R5, no greater than 4 feet. And those are at least 8 feet, I think, at that point. They are not retaining walls there. And the same would be true for partial the garage entrance, but mostly the entrance there.
Okay. And they're stuck with what the code says in terms of how far they can extend, and they're not seeking relief for that issue here. So when it comes time to land development, if they're non-compliant.
Well, just let me clarify. My understanding for a special exception, in order for them to get that, is they need to comply with any specific requirements of the special exception, as well as any other zoning requirements of any general use in that. So to me, a lot of these other things do come into place. There's 3 prongs. There's the specific requirement for that. There's the requirements for any use within that district, and then there's the health, safety, and welfare, where the burden shifts to the non-applicant.
My concern would be that then we'd be opening the door to everything.
But I believe that's
limiting.
My understanding is that's the requirement for special exception.
Well,
that the burden is for them to prove both of those prongs.
John, would you like to comment on that at all?
Well, I mean, if there's two steps here. First, was the zoning officer correct in referring it to a special exception?
I understand.
If the board concludes that the zoning officer was not correct, then I think that we don't get to whether a special exception lies. If they do need a special exception, then I agree they have to comply with the requirements for a special exception, and they have to. If they don't comply with the requirements for a special exception, then they drop into a variance, which obviously is a much tougher approval to obtain and requires a showing of unnecessary hardship, and that depends on, in this case, if the board were to conclude a variance were applicable, I still would say it was dimensional and subject to the Hertzberg standards as opposed to a use variance. But if the board were to conclude this is a separate use, then you've got that issue as well. But I think it depends on where in the cascade the board makes its decision. If we agree with the applicant, the board rather, not we, the board agrees with the applicant that the zoning officer was incorrect in issuing that letter, then I think we stop there. So it depends where the board ultimately decides to travel on this.
Mr. Gemmer, would anything left?
Yes, one more item. If you look at the R4 uses, if you have to, a lot of those are recursive. You kind of follow them back, R3, R2. And if you follow it back to, I believe it ends up being R1, where it talks about parking, and that's an accessory use. Just to emphasize, that is a separate use from the mansion in terms of it expanding on its own and not counting the fact that the mansion is existing.
But it's accessory, that's the thing.
Yeah, but it's still a non-conforming accessory use.
No. It's a required accessory use.
Mm-hmm.
And so it's non-conforming in that they don't have enough parking spots.
Also in dimensions and front yard and things, but yes, it's non-conforming in other ways.
Right, and they're under the code, as the testimony has been presented, reducing those existing nonconformities. Those are dimensional nonconformities,
No, I
by the way, as
understand.
opposed to use.
I'm just going to the fact that it's a non-conforming and hence falls for under things like the enclosure portion, that it is a separate non-conforming use, regardless of how it's non-conforming.
Now, don't confuse use and dimensional nonconformities. It is a. This is just my opinion.
No, I understand.
My
what
opinion
you're
is that
saying.
it is a required accessory.
I understand.
Use. Go ahead.
No, that's all I have.
Yeah, that's a
you.
legal question for the board. Is the parking on this property a separate use, or is it part of the non-conforming use? And that's ultimately for the determination of the board, and that's an issue before them.
Yeah, okay, thank you.
That's all I have, thank you.
And I'm sorry, I had one question for
Okay, sure.
For me? Yes.
Yes, sorry.
Yeah. Do you know what section you were talking about with height?
In terms of the, if you want to bring out the map, I can show.
I'm sorry.
I'm sorry, the section of the code? Oh,
Yeah.
28109, matter of fact, I just read it. 28109, no fence or wall except for retaining walls or walls of a building as permitted under terms of this chapter shall exceed a height of 6 feet, provided further that within R4 and R5 districts, no fence or wall erected within the required front yard setback shall exceed a height of 4 feet.
Okay, and do you know how building height or wall height is measured?
From the grade, yes. Usually it's 10-foot intervals. It depends on the district, but
Around the whole thing?
well, in terms of a wall, the wall has to be measured where the wall is. You don't measure. I'm not talking about the building. I'm talking about that specific wall.
That wall's part of the building, right?
That's right, but this is not addressing building height. This is addressing wall height. There's a difference.
I understand your position.
Thank you.
Any other members of the public wish to make a comment? Okay. With that, we'll close the record on this one.
Sure, I make a motion to reverse the determination of zoning officer that is not an expansion of a non-conforming use.
Okay. Noah, what's your thought?
I second the motion.
Cora? I agree as well. Thank you. Welcome back, Mr. Falcone. Norma, do you need a break? Okay.
Are we taking a break?
We're going to take a 5-minute break.
copy this. Yeah, I'm ready. Someone, everyone? Oh, John. But I told him, I knew it was. I knew it was. I've said that. I know that. I know that. I tell everyone. I said, don't go in. I said, you're wasting your time. I said, you're wasting your time. You don't, you know.
Not happening.
Yeah.
Are we ready? John back? Ready, John? Okay. Appeal 2858, the appellant, Ona Kasky and MICPLP, property located at 411-413 East Lancaster Avenue, Wayne, Pennsylvania, and is zoned R5. Applicant seeks to install in the rear of the two buildings an enclosed one-story connector between the two buildings in which he operates her business, Harmona Spa. Applicant intends to consolidate the two lots in order to eliminate the need for a side yard variance. Applicant seeks a variance from Section 28034 or a variance from Section 280-101A2 or a special exception from Section 280-101A2. This is a continued from the July meeting.
Evening, Nicholas Cornelia.
Thank you. And I apologize for moving you back, and thank you for being patient.
I presented to you, A11 is already part of the packet, just a prettier colored version of it. But it was when, you'll notice I filed an amended application, and what we did with the amended application is remove the property line, and we're now merging the lots. So it would be based on any relief if it was necessary, or if we proceed, obviously it would be with the merger of the lots. We'll have to go to the Planning Commission anyway, because it's a land development, even though it's a small addition is being proposed. And you'll notice on the plan a couple things that we're doing. We're actually decreasing and eliminating some nonconformities, because in fact previously with the line down the middle there was a nonconformity as to side yard setbacks with the two buildings. We're now removing that line, so that eliminates the nonconformity regarding the setbacks. And in addition, it eliminates any setback relief that would be required for the small addition. Remember, the small addition, the purpose of the small addition was to facilitate the ability to transgress between the two buildings, to provide handicap accessibility, and basically to provide an area where people can enter from the parking area and go to the buildings, and also so that someone in one building would not have to go outside to enter the other building, because actually there's functions that go on in one building and functions that go in the other building. If Ms. Saski testified tonight, you'll hear that this addition is actually essential to her business survival, so that she could connect the two buildings here. A couple other things we're eliminating is we're now expanding the lot width. It was there was 60-foot lot widths here. We're now making 120 feet, which complies with the ordinance. We're decreasing impervious coverage from 74% to 70%. One of the lots was non-conforming as to parking, but by combining them, we have sufficient parking under code requirements for the entire lot now, so it eliminates the non-conformity. We're also removing the curb cut. You may recall there was 3 curb cuts on this property, one in the east, one in the middle, and one on the west, and we're removing the middle curb cut, which was discussed last time before the board, and that would be additional landscaped, as well as the landscaped courtyard area in between the two buildings. And we're also providing for one-way traffic. Currently, all 3 curb cuts provided for two-way traffic, providing one way in on the eastern side of the property and goes around, and one way out on the western side of the property. As you're aware, as you can see here, this addition isn't even visible from anyone except from the condominiums that are behind this property. And we actually have, we had a letter last time indicating that they had no objection to the relief.
Nick, can I ask you a question? You're talking about a variance from section 280-34. Did we mean 280-35?
34 would be regarding the use, and so I think that's why I put that in there, Noah, if we need a variance.
I mean, there was a prior variance permitting this use.
There was a prior variance
As a
permitting
spa,
this use. And
yeah.
so that's why, if we need a variance to expand that use, that is why I requested it from 34, I believe, which is the use section.
You have two variances for each building, correct?
We don't have any, there's no dimensional variance required now.
No, I'm talking about the history of the property.
Oh, yes, we have variance
Each one
for
of
each
those
building,
buildings,
yes.
and I think
That is correct.
you're now putting them both on a lot. I do think the board needs to look at that and maybe amend the variances and maybe think carefully about how the variances are amended if the board wishes to do so at all. For example, you have one building that's got a variance for one use and another variance.
No, they're both for the same use.
They're both the same. They're both spas now.
They're both
spas.
They were previously. What happened? You'll notice that they were actually previously. I believe there was some other type, an office type use.
Oh, okay.
But when Alana went in and bought the property, she went in also and got the variances for the spa use itself.
Okay, so both are now have variances for the spa.
Well, there's one here for 413 East Lancaster.
That's the old one,
And that says spa.
Yeah, right. And there's one for 411 that says.
Is
I
that
think
in our
I attached
materials?
all of them. That's they're attached. Let me see if I can find the one. It's A13 and A14, I believe.
You see 411?
A13, that's the one.
There's the one that says spa.
No, that one is a.
411, I'm sorry, it's A16. It's an A15.
Okay, how come I haven't got an A16?
It's A15. I'm sorry. It's A13 and A15.
A13?
It's actually A13, A14, and A15. A13 and A14 deal.
Well, let's see what this is for.
I am sorry. No, it's A14 and A15. A14 deals with 411 and A15 deals with 413.
A14 is for...
411.
That says skin and nutritional care facility. It doesn't say spa. Well, I'm just saying, let's get it right. I mean, you have one that says spa and one that says that. Are they the same thing?
They're both the same thing.
Okay.
You talking about both buildings, Noah?
Yeah, the variance for one building says one use.
Okay.
The variance for the other building says another use. They're similar, but, you know,
No, that's the
to the
point.
uninitiated, they're not the same.
And I'm uninitiated, but I wouldn't have read those to be the same. I mean, I think that it needs to come to the board because it is a modification of a variance. You're merging the properties and building the variances are each granted on the basis of those individual lots and what was on those lots. And now you're basically you're expanding, albeit through maybe a very positive connecting thing as part of this variance use. And as Noah indicated, as uninitiated, I didn't read those two as exactly the same.
So the uses are the same, John. Nothing's really changed outside of, as to the uses itself. And
I'm not saying it's
I can have
appropriate to
Ms.
grant this
Saski,
relief, but I think that-
and she's been there. She's been getting permits from the township since 1982 for the one building, and I guess when she purchased the other building sometime in the last several years, the same. I'll have her testify if the board wishes as to why this is essential and why she would be entitled to variance relief.
I would think that the day spa use is actually broader, allows for a broader level of activity.
Right, because
Wouldn't
one
she
is
be-
general and the
wouldn't
rest are
she
specific.
be better having the variance applied to the whole property?
Yeah,
and a broader
I kind of think
terminology?
it does, but if the board feels it's necessary to modify it so that it's clear.
I think I was not at all suggesting, one way or the other as to what the board should do. I just think there is, if the board approves this, it ought to be clear as to what the board envisions this newly combined property to be in terms of its use, so that it's clear what the use of the property, this new enlarged.
But the use is now not non-conforming, right? It's under variances, so
Yeah.
that's okay. How about the buildings? Are the buildings non-conforming?
No, the buildings are actually conforming now
conforming.
because we're removing that property line.
Okay. So then you're
If
here
they were
why?
non-conforming,
You're here
they-
why then?
No, because they were non-conforming, this property line made the side yard setbacks non-conforming.
Right, but now that you're merging the lots.
Do you need any relief at all?
Well, the only relief we would need, as John and Noah are suggesting perhaps, is because if they're based on variances and we're expanding on the variance, do we need another variance to expand on the old variance, even albeit that it's a very small addition to these buildings?
You are
No,
changing.
these are combined properties now, right?
They will be combined.
Right, so it's going to be one property.
One property.
Right.
But there is no right to marry two variance uses. A variance, you get what the variance tells you you get, and that's it. It may make sense and to merge them and reduce nonconformities, and that would be a basis, but it does need to go by the board, and the board has to make a determination on that.
And we gave a variance for a spa in one of the buildings, and the other one was what? Skin care?
It said skin and nutritional care facility.
Aren't they interchanging? I mean,
No, the spa is more generic.
okay.
And the skin and nutrition, she's limited to skin and nutrition. Spa, you can have nails, for example.
Oh, that could
And
be
hair.
argued to be skin or nutrition too, so it's,
Are you not going to do that anymore?
no, she's
She's
basically doing the same thing that she's done since 1982.
Is she not going to do the skin and care thing anymore?
No.
No, she's been doing.
Okay, and she's going to do it in the same building she did it before?
Yes.
So what's the change here? There is no change.
Well, there is because
Two properties are gonna
because
become
there's
one.
No. This, she's
Right,
built this.
I understand that.
So theoretically, it's an expansion of use
Yeah.
for which variance relief had previously been given.
Yeah, you granted these two little
So
buildings,
you have
not
to be
two little
granting
buildings
a
connected.
New variance as to both because.
Yeah. Yeah, you're adding,
The buildings went like this.
I understand that.
Expansion. So we have to give her.
You have to
if
do-
we're inclined to do so, we have to give her a new variance.
yeah, you have to give her a new variance to clean it up.
Do we have to advertise that?
She saw it.
Yeah, she asked for
I asked
no.
for it. I asked for it.
Oh, you asked for it too?
234.
Yeah.
Okay, for record purposes, my suggestion would be to have her come up and,
Okay.
does anybody disagree?
No, that's good, that's it.
Just the sketch.
My name is Ilona Chaki. ILONACSAKY.
And- Yeah, and Alona, you were previously sworn, you testified here last time, and you're still under oath, you understand that? Okay. You started the business here, when, 1982, I believe?
1982.
Okay, and when you started, has the business or the business itself changed to some extent since 1982?
Completely changed. 1982, nobody even knew the name aesthetics. I had people, anesthesiologist, architect came for the job because nobody knew what was that. And that time I requested for a skin and I don't know, nutrition because I was doing nutrition also, and it's under was like massage. And this was very new and unknown. In the meantime, things changed and evolved. And now anybody, even if they do a little nail and face, they say spa. So now this is the common word for it. And it's changed very much so. We started out doing skincare, and I did nutrition, and now everything is changed in the last couple of years. Medical field and spas are starting to integrate. I just got a week ago a webinar from the Mayo Clinic and encouraging us how to integrate the medical field and go after the rigid medical field, because we have to help the people to more preventive than just healing other things. And
So let me just...
so it's completely different now.
Okay, so probably when you first started, it was more of a luxury, and now
It was a luxury, and after more and more people worked in a lifestyle, and this is now coming to be more like a necessity.
it's necessity from a medical standpoint and
Yes.
healthcare.
Yes, healthcare. It's more like wellness. Everybody's after that. We want to stay healthy.
And it's like preventive care as well, treating anxiety and diabetes.
It is, yes. The study was since 1970 they did the studies, and then they say anxiety they can cut 52% improvement.
Somewhere in between. You can do that.
Here, why don't you try this one, and I'll try the other one.
Okay. So anyhow, now, this is a part of the lifestyle, and if you want to stay healthier, you want to be more preventative, and even we're doing post-surgery treatment and pre-surgery treatment, and it's different. Our clients, I was calculating approximately 50% of the clients between age 50 and 75. 75 and above, approximately 10%, and 25 to 50 or so, it's another 50%. So it's different, completely different. Name changed, treatment changed, people, the way they're looking at the treatment changed.
Now, is this bridge essential to survival of your business?
It is survival. If we cannot do it, we have to move.
Why do you say that?
Because when the guests come to us, then we have the two buildings, the layout is different. We're able to do different services. One of them we do yoga, qigong, tai chi, and different workshop. Other building we're able to do other things. And the client is coming to different services. We literally, they have to come and register in one building. We do one service in a robe and a slipper. We have to walk them over, rain or shine, and they have to. We do the services over there. They have to come back and pay. It's just cannot happening. We can't do it. People are not going to put up with it. So.
And it's really a safety issue to get your customers
between
parking.
The two We're working on a parking lot.
It's a safety issue.
Yes.
Okay.
So we cannot operate any longer. We tried. I told
issue, right?
it's going to be good, but it's not working.
And it is a safety issue?
Yes.
Okay. I have no further questions. The board has it.
Anybody on the board? Any questions? Noah? Brad? Cora?
I would just ask the exhibits to be part of the record.
Okay. Anyone in the audience have any comments? Schnelling? Nothing? Good. No, I understand that, and you were short last time. I wanted to stand up and cheer you. The fact that you were so short and concise, it was very, very refreshing, I have to say.
The real trick here is to figure out the fashion and the relief. How are we going to?
Okay, Jim, you want to do this one?
Sure. I would propose that we grant a variance requested. In large part for the reasons expressed in the prior opinions in which variances were granted. And with respect to the alleged expansion, I find that to the extent it's expanded at all, it to be de minimis expansion of the non-conforming use.
I agree, but I think we have to add that these lots have to be combined in order for us to go through the variance.
I agree
correct?
with that condition,
Okay.
yeah.
Do we want to push the variance, gear the variance to the plan, so it's for this combined lot with this extended building as one?
Yes.
And that's conditional on that.
Very good suggestion.
Right. Is the use going to be spa now?
Which use will you prefer? If you want us to call it spa?
Yeah, I think it's
Spa.
Okay. Cora?
Yep.
Noah?
Yes.
Yeah.
I also. Okay.
Thank you, guys.
Thank you. Thank you for waiting. No further business. See everybody in October.